Good morning, Sat Sri Akal, Namaskar, Adab. This is my 185th video. This will be covering a very bungalow which falls in LANDOUR cantonment. It's a case of Mr. V.K.UNNIYAL versus Union of India. Friends, this case after Mr. Unniyal's death came through me in the Supreme Court, and we will discuss every chapter of this case. And I would like you all to understand why am I talking to the regarding the lower court, session court and high court, and then finally how does the Supreme Court interpret these kind of. So Mr. Unniyal on 19th August 1985 for survey number 11 WOLFSBURN, having an area of about 3.39 acres, was given a resumption notice, and under the same order that the land belongs to Governor General Order under GGO 179 of 1836, and a meager amount of about 17,125 was offered to the compensation amount formed by a committee or whatever at that time in 85. And this notice was signed by Under Secretary Mr. A.K.GOMAL as Exhibit 22G. Now, what is the actual case? Now, Mr. Unniyal at that stage, as per his knowledge in acumen, since he was a professor, I believe in English in the IS Academy, Missouri, he did not file a suit for declaration. What did he file? He filed a suit for injunction. That's called permanent injunction. Now friends, this is very important. So what does he file? He filed a suit for permanent injunction, very clearly stating in that this notice is frivolous, and if he has to be evicted, it should be in due process of law, and the compensation of 17,125 is wrong. He, during the purchase of the properties in 1980s, had to spend over and above about 1 lakh rupees to maintain the bungalow. So his compensation needs to be re-evaluated. Now this is a very core issue here. Please understand, he does not file a suit for declaration. What is he filing? He is filing a suit for permanent injunction. Well, this property was bought from SARDAR JODH Singh. In his sale deed in 80s, he had admitted that the land belongs to government. Similarly, Mr. Unniyal also admitted that the land, and finally their admission deeds also flew into the procedural of mutation. This property in 1948 through a probate order from the court was inherited by Mrs. E. Walsh, who had nominated a testator who would finally make the sale deed. So on 20th March 1948, this property exchanged hands with Mr. SARDAR JODH Singh, and finally it came to Mr. Unniyal on 14th August 1980. So there is this will which talks of Catherine Jane, who had appointed Walter Augustine and his another son, Sir JHON, the rights of this property, along with a nominator called Cathy Alice Gordon. And when was this will made? This will was made on 14th February 1895. So that means WOLFSBURN existed in 1895. Friends, I am talking of all these facts, but Mr. Unniyal did not have a sale deed prior to 1948. So, well, this case for permanent injunction moves to the court. He is granted injunction against the department that he shall not be evicted. So, further now evidence is led. A clerk from the Dehradun Registry Office gets moreover the land records prior to 1942, and where he very clearly says that all these land records were earlier with the cantonment magistrate from 1842 to 1942. But these availabilities of records are in the registry office Dehradun, which were further shifted to Saharanpur. So these documents have been clearly stated and exhibited through an Exhibit 82C, which carries a plan of Lieutenant Colonel Pillet. This is the same plan, and during the same period when Captain Young was instructed in 1842 to make a survey of Landour and Missouri, Doon cantonment I would put it, dated 23rd January 1849. So these registries by the station staff office Landour on 15th January 1852 clearly shows that the bungalow has been in existence since 1837. Just imagine, this bungalow was in existence in 1837, and as per a document exhibited, it was paying a rent, or we could use lease money of an amount of 1260. This is what the registry clerk Saharanpur shows through a letter number 485 of 1985. So continuity, sale deeds were shown, those were exhibited, will, family purchase. So all these documents came into this case. Nowhere the documents from prior to 1948 were brought by Mr. UNNIYAL. So what do? You know, the travesty between bungalow owners is that they are so educated. I have been categorically saying that these cut dates are very important. 1937, 1924, 1912, 1899. And just imagine, this bungalow has a will of 1895, but there is no sale deed. So these sale deeds which were brought from 1948 to 60 and then 70 and then finally UNNIYAL Sahab, all these suits, sale deeds were showing admissions that somewhere the land belongs to government. Now this suit for injunction which was filed by Mr. UNNIYAL, what does he plead in his plaint? This is very important. The very first para he speaks of ownership in possession, and through what? This is very important. Through a sale deed of 1980 from Sardar JODH Singh to Mr. UNNIYAL. Now he doesn't have anything prior to that. And Mr. Sardar JODH Singh from WALSH 1948 through the will. So this is only what he has, and his local advocate makes him state through a pleading in the very first para that he is the owner in possession of the bungalow, WOLFSBURN, survey number 11, through this. So the main claim stands, he is an owner and in possession. Now, in subsequent paras, Mr. UNNIYAL's advocate even raises the issue of Article 14, Article 19(1), which all speaks of discrimination, right to property, and even admits in a plaint para that his bungalow falls within the cantonment boundary pillars of the Landour area. Now you have, I would call it destructive pleadings. He says, I am the owner. On what document? 1980, where the sale deed clearly reads that land belongs to Union of India government. So what is he trying to do? Is he trying to say I am the holder of occupant? No. Here the advocate says because he's been in possession for 80 years and above, so his adverse possession stands. Friends, we really need to understand, things have changed now. YouTube's, internet, WhatsApps, photocopies, grow up. So immediately after this, in the concluding para, Mr. UNNIYAL is seeking compensation. So he's saying I am the owner. 17,125 is wrong. So guys, you pay me well. I am in the cantonment boundary pillars of LANDOUR. My sale deed, I call myself owner because I am in adverse possession. Everything array. Nothing at place. I am surprised how does the legal luminaries even file such cases. These are basically pleadings which are self-destructive. So the basic point what I would understand from his plaint is that he is simply saying, don't take my bungalow without due process of law and by compensating me. And he is admitting the rest. DO merit is brought in for evidence. He clearly, like a normal DO would say, Mr. UNNIYAL or the predecessor had only inherited occupancy rights. And he very clearly points out to the paras of the sale deeds where admission of government land is there. Second, all lands within the cantonment boundary pillars, JP Mittal, and he says belong to the government. So now whether the opportunity before resumption for calculating or valuation of the building was given to him, we can always formulate an arbitration committee if the owner agrees to the government rights. So guys, you give up yourself, then the government will give you a pleading and an arbitration committee will be formed. So this is how the government understands. It rates you at holder of occupancy, it rates you through an admission, it rates you if you want compensation, admit government rights, and then we'll give you. So by these kind of depictions, finally Mr. K.R. Kumar, who had given an affidavit on behalf of Mr. D.O. Merit. Now Mr. UNNIYAL filed an Order 12 Rule 8 application, which is production of documents. So what is he seeking? He is again asking from where is that grant of GGO 170? Nowhere. But the DO moves in another application. He files in some more documents. Now what is he filing? He is basically filing those admission deeds and various things, what he could do to prove his case that this land is actually of the government. Nowhere Mr. UNNIYAL is filing or his advocate is filing objections to those documents which have been tendered. So what are you left with? You're accepting, you're asking for a grant, they're not producing it. But when they tender some documents, you're not countering it. Now it is very important in a suit for injunction. Just imagine what were the issues made. Whether the plaintiff is the absolute owner of the property in dispute, and as such, the property cannot be resumed. If I just brief people here itself on this issue, who says that the government cannot resume a property even if I am the owner and outside the cantonment? The Land Acquisition Act permits the government and the sovereign government to acquire any land. What kind of issues? And our advocates don't dispute. And then simple order, whether notice was bad for ATC, whether defendants have the right to resume the property, and is plaintiff entitled for compensation. So now here just try and see what the court is doing. It's clubbing two issues into one. Why can't we get 6 issues or 5 issues separately? Whether I am a grant given under GGO 179 of 1836, if I am a grant, how would be my compensation? Will it be under regulation 7 and 8? And if not, under a policy of the government of India? So there are so many things which we can crop up to issues, but nothing is brought in. So where are we left to? Now finally Mr. UNNIYAL, on his arguments, he is tendering written arguments. I can understand, court allows him. So what are the normal procedures, how procedures adopted? This all keeps going on in this case, and there is nothing to, yes, there is some good documents which have been exhibited, but they have not been used. Documents have not been vetted and proved. They've not been put to question in the cross, either to the defendants or when the defendants moved their evidence. So Mr. UNNIYAL's basically entire case, final order of this suit 484 of 1985 came on 17 September 1997. So the court very clearly says Mr. UNNIYAL is not the absolute owner of the property and the defendants have the right to resume it. So this issue goes against him. After resumption, his only entitlement, after resumption, the only entitlement is for compensation, which he can definitely move in an application, and with different legal rights, he can pursue that. Natural justice, an opportunity for hearing must be given to him while deciding his company. That's it. So the suit for permanent injunction with an issue of ownership is decided. Now Mr. UNNIYAL reaches session court. Now here there is a little dispute. Because at that time Allahabad 1997, Allahabad High Court was there. So he filed an appeal in Allahabad High Court as appeal number 69 of 1997. Same grounds, but this appeal finally is redrafted and it moves to Nainital High Court. So this appeal is on a different platter. So session court, we were talking of the session court first. So the session court here again bring forward the same pleading, and he says, no, Mr. UNNIYAL, your bungalow is an OGB under Grant GGO, and he upheld, and he slightly, partially I would say, he converts the compensation finding to a little different. Yes, Mr. UNNIYAL needs to be heard, so compensation must be decided and then resumption should take place. So there is a little partial change that the land belongs to government, but this notice becomes null and void because the compensation was not decided arbitrarily with Mr. UNNIYAL being a part of it. Finally, Union of India against this order moves to this Nainital High Court, appeal number 1795 of 1998. What is the whole case standing in the Allahabad High Court, which finally moves to Nainital, but I would like to read what was the question of law made there, because I had that file, it was shared by Ms. Archana. Whether notice of 1985 would be entitled to defendant to resume the land and dispossess the plaintiff without giving an opportunity of getting compensation. Absence of evidence, can ownership in favor of defendant be taken away merely that land within cantonment boundary pillars belongs to government. Whether except Crown Grant Act was in place and reliance was not placed on the records. Whether in absence of proof of Crown Grant Act, no evidence was on record in support of the case. So finally this case gets shifted to Nainital, appeal number 296 of 2001, and this was decided in 2008. In continuation, now when the Department, Union of India, is in High Court Nainital, what is the observation which is being made? Now in this, I will not get into the nitty-gritties. Para 18 and 19 are very important of this High Court judgment. You know, the High Court overturns the entire findings of the lower court and the session court. Without entering into any dispute, appellant will not be evicted from the property without in accordance of law. This is what the finding comes. Eviction proceedings are to be proceeded against the appellant. Findings of lower court and session will not affect the rights of the plaintiff. Now this para becomes unbelievable to the Union of India, and it's rightly. So friends, if you realize what is the High Court saying, let a resumption notice be there and let the department move in accordance with law and finally take eviction. Now, in what order will they go for eviction? They will move a PP Act. And that's how under 51B they will ask you to vacate the bungalow. So, you can definitely challenge the notice, argue it in the estates court, and then if you lose or win, you can move to the sessions court. So, what you miss is the lower court of the courts, but you have the estates court. And then you are neither the plaintiff, you are the defendant or the respondents. This is where I am trying to say, this is what High Court said. Union of India against this para 18 went in for a review, which was again dismissed on 19/6/2008. And then finally an SLP was filed in 2009. With a little delay here and there, the condonation was sought. But we must see what is the government and what is the SLP speaking. These are very important things. And sometimes our advocates feel very diminished, very low to use some harsh, abrasive language towards the court findings. Look at now, I'll read this. Whether High Court ought to have considered the finding of lower courts in session are incomplete in accordance with law. So clearly in SLP saying the High Court was wrong and this is how it is. Whether High Court can null the whole litigation which took almost 23 years, and will the dismissal attract residue cata? On what? The ownership part. Whether High Court committed an error in reopening in its concluding para, findings that lower court session findings will not come in any way. The appellant will be at liberty to take defense. Whether the 3 sale deeds shown ownership of government was rightly taken by the lower court and session court. Whether High Court ought to have considered that land trees were never purchased by Mr UNNIYAL or his predecessors. Whether High Court did not appreciate that GGO 179/1836 was applicable and all sites were resumable. Whether trial court is incomplete in accordance with law in deciding issue number 1 and admission has come from plaintiff. I feel very obnoxious when these kind of SLPs are filed. They are so straight, simple English. Look man, this is what you did and this is what it is. The truth must come in front of the court. So why feel scared in writing something to the court? So the narrative set by the Union of India was, it all starts from 1948. Nothing prior to 1948, guys. When Edith Walsh finally inherited and there was a will, and that will finally in 1895 brought G.N. Clinch, and there was an extract of a grant register which was exhibited in this case, never wetted down below. Now this is where most of the bungalow owners in LANDOUR hype on. I remember, when I was in touch with Mr UNNIYAL from 2009 till I think 11 or 12, and I wanted him to come for my convention. Well, he was a well-read man and he had his knowledge, but he had some reclusiveness in him and he never wanted to share anything with me. I kept asking him that you lost in lower court, session court, now you're in High Court, so why don't you? So High Court also, he said, Ronnie ji, I have won my case, so the department is gone and I have faith and I have this. Never ever till 2009-10 he let me read his papers. Never mind, bad luck. Finally, when he died, it was very unfortunate during the pendency of SLP. His daughters, Archana and his wife came in touch with me because I was dialing Mr UNNIYAL on his landline number, and all of a sudden I was told that he is no more. So what is the agenda now in SLP? What is the government setting? It begins from 1948. It talks of a will. it brings that grant register. Second, the biggest judgment, that is Harish Anand 1996 Supreme Court, it brings. It says yes, Mr. UNNIYAL is entitled for compensation. He needs to be evicted, and then in his question of compensation will come. Now just imagine, here the government is speaking of 23 years of case and doesn't want this case to be re-adjudicated by the DO or in accordance with law. But in Mannalal Agarwal case, Aurangabad, after 67 years, the same Supreme Court remand backs the case by saying that because cantonment boundary pillars of Aurangabad were not brought in, so this case needs to go back. And 67 years you fight the whole chain, you are in Supreme Court, winning all the courts, Mannalalji, and then you are thrown back to the lower court. I've already made that video. So this application comes, and then finally admission deeds, GGO, possessions, topics like and B3, when was B3 given in Regulation 6, where it clearly talks of and residue cata can be pleaded if there is an issue. Did any of these sale deeds from prior to 1942 speak of land belonging to government? DO's affidavit comes in this SLP. Again, he talks of cantonment boundary pillars, doesn't mention military boundary pillars, does not talk of why admission deeds have been started flowing since 1937. Here now Mr. UNNIYAL through D.K. Singh files in counter affidavit. He is again insisting on that where is the grant, where is the notification of GGO. His peaceful possession should not be disturbed. So High Court was right, and here for the first time he says that it was a suit for injunction and the ownership issue cannot be decided. And I must impress on that in this case, finally the Supreme Court gave an order that the Union of India may be told to produce the grant of WOLFSBURN. So ultimately that fizzled out because Mr. UNNIYAL died, the advocates changed, and the young girls brought in CU Singh, and the background is not very good, unfortunately, why everything was churning. And I think somewhere in the later part, even I felt that these girls were using me either also. And they were using me at the behest of a bungalow owner, some Mr. I really don't want to name him. But yes, he had about 3-4 bungalows, running hotels and everything. So the backdrop was under his guidance, the whole show was moving forward. Because Mrs. UNNIYAL had received a notice under section 244 of commercial activity. Similarly, about 7-8 bungalows had received that in LANDOUR, and mostly all of them filed their fines of 5,000, 6,000 or maybe 10,000, and they gave up the idea of fighting. I actually took that case also to a next level, along with this hotelier who was also issued a notice. Now these rejoinders, again, you'll be surprised. It talks of the entire Regulation 6 of GGO 179. Again, it talks of Surinder Kumar Vakil's case where the GLR has been upheld. So there is an extract of the GLR which has been brought in. So all this is happening. You have written submissions by Mr. UNNIYAL in 2010. Again, he talks of some sections in the Evidence Act 61-62 for primary and secondary evidence. Two basic judgments which all bungalow owners were using till 2013-14. And they were Purushottam Das Tandon and P.T. Ankleshya. The word is in accordance with law. Purushottam Das Tandon's main part of the judgment is produce grant. So this is how this went on. And I'm sorry, I feel bad. I was not that equivalently educated in 2011-12, but yes, the laws were in place. And we could have definitely done something better after if I had gone through this case. This entire file came to me through Archana somewhere in 2010. And then I was stunned. A suit for permanent injunction and an issue of ownership. And you continue till lower court, session court to get that issue decided. So what are we doing? So we did work hard, and I wanted the young girls to be brought out of this mess. But somehow, there is a problem when you inherit some senior counsels. They don't want to see me as a man from cantonment laws and knowledgeable. So their ego clashes. Every time I had to take a conference with Mr. Singh in Delhi, it was like I was waiting, not him. As if I wanted him to be briefed, not he who wanted himself to be briefed. Every time he used to question me, why this, why that, he was the devil's mind up there. Gradually I started realizing that is he talking of WOLFSBURN or is he talking of the rest of those 4 hotelier bungalows which were running hotels? I could sense, I could read through his lines. He was not actually talking about WOLFSBURN. He was actually talking of what are cantonment boundary pillars, what do you mean by military boundary pillars, how do you say old grant, how can you define a grant or a grantee. So these were the kind of questions which were not putting me 100% with the girls there. I kept asking, we had conferences, finally this AOR had filed their application and this case came up for hearing in October 2017. I had been attending those Supreme Court hearings and arguments, how the Council for Union of India started shouting, 25 years we fight, again you want us to remand back this case, let the High Court decide, the issue of ownership is already decided. Somewhere the court was ready to remand back this case to the High Court since the High Court had not adjudicated on the question of law under section 100 of the CPC. But I don't know what took the turn because we filed a judgment that injunction suit ownership cannot be decided. But when you are actually leading evidence, pleading ownership, then why can't this be done by the courts? There are a number of judgments against that either. So, I was getting frustrated. Finally, this happened and the court did not remand back the case. It wanted us to proceed with our arguments. What all I could share at that stage, which wouldn't have affected people further on, I shared with the advocate, and this case came up and finally Civil Appeal 15836 and 37 of 2009 was pronounced. And it was again the same story. They overturned the High Court judgment and they said the lower court has already given a finding. So now the topic left was only of the second part, whether Mr. UNNIYAL needs to be compensated. So the entire High Court, while dismissing the second appeal filed in the original, being devoid of merit despite upholding the concurrent findings of facts recorded by 2 courts below the ownership of the land, was it that High Court justified in making an observation which has the potential of reopening an already settled issue of title in respect of the property. I must mention some of the advocates in lower court speak why Roniji full typed letter or GGOs in the plain. Now, if you take the SLP of this case, take the DO's affidavit in Supreme Court, you will find the whole GGO printed, the whole resumption notice printed there. So guys, please, I don't talk shit, I talk sense at times. I know some people don't like me at all, but there are these, you will not be able to win resumption cases. If somebody is harping whether in LANDOUR that fee simple will get them the case out, It will not. Fee simple and a grant register means entirely different to what the pleading will come from the department side. You may say I am a freehold property, you may say I am an ownership, you may say I am a fee simple because it is written on your grant register. So, nobody has read. Actually, when was that grant register? When, I was sitting with the DO in Supreme Court and this grant register was there. Very sweet of the DO, knowing for me for the first or second time, she actually showed me, and she showed me things which were not to be shared, and I'll not share it with you. So guys, you don't even know when these registers were made and what are the errors in those registers. So you have to understand, what are we trying to do? So this suit for permanent injunction entirely ruined the entire thing, and alternative relief of compensation was accepted till some extent in a para 35 and 42 of the judgment. And finally, whether adverse possession or not, whether he was paying rent, everything becomes immaterial. So the same thing repeats, issues are made, whether plaintiffs, the judgment of Supreme Court talks of lower court, session court. Now here there is a very important thing which it talks of, whether both parties pursued evidence on documents available on record. Question before me is to whether the appellant plaintiff happens to be owner of the suit property. Second question is whether notice dated that this 1985 issued to the plaintiff, the same was as per rules. As far as ownership is concerned, these documents are very clear. Now, whether this is a grant under fee simple, again those documents 20C, 27C, 35C and 38C exhibited in the lower court are what? Are admission deeds. So here the court is very clearly saying, look guys, this is it, it's been done, ownership has been decided, so don't repeat this. You want compensation, we can think of it, so that right remains because it is there. So everything is thrown out, and finally we are countered through this admission. Now when Mr. UNNIYAL approached, or the Ministry of Defence approached the Nainital High Court and the amendment of the Session Court's order, what was the basic point, law point which was framed? The appeal was admitted on substantial question of law, which we all understand, whether the notice dated 1985 would entitle the defendant respondent to resume the land and dispossess the plaintiff appellant without giving him opportunity of hearing of determining the amount of compensation. The second law point was whether, in the absence of any other evidence adduced by the defendants, respondents on the basis of alleged admission of the plaintiff appellant alone, the property can be held to be belonging to the respondents and can thereby be resumed by them. So what is the court trying to say here is very clear. It is fixed two parts in a separate way. One, whether compensation on that notice is to be heard and then decided, and the other part it is reducing whether the alleged admission taken by the defendants could reduce them to the rights of land belonging. So the High Court states in his para 15, so far as the aforesaid submissions made by counsels of the appellant with regard to ownership is concerned, both the court below have given the concurrent finding on this issue and have come to the conclusion that the property belongs to the Union of India. Para 16 not to be read. Para 17, counsel of the appellant has pressed on the registered sale deed of 1980 executed in his favor, which shows a prima facie case with regards to ownership of the property in dispute in his favor. Perusal of records also revealed that the plaintiff has been in possession of the same. Para 18, without entering into the title over the property in dispute, it is made clear that the appellant shall not be evicted from the property in dispute except in accordance with law. The appellant shall get full opportunity if the eviction proceedings are initiated against him. The findings recorded by the trial court as well as appellant court shall not come in way of the appellant, and the appellant shall be at liberty to take his defense, and the same shall be decided in accordance with law. Subject the aforesaid observation, second appeal lacks merit and is dismissed, no order. Now the main statutory in accordance with law and eviction will take place in the same manner. Meaning hereby that Mr. UNNIYAL should have let the Department or Union of India, Ministry of Defence, move PP Act eviction proceedings, and the parties would have led their evidence before the eviction proceeding, but we are the best and then we don't want to listen to anybody. So without realizing this entire onus, we rush to the court for a stay. And then we file a suit, whether it is a suit for declaration, whether a suit for injunction, and we plead ownership on those frivolous sale deeds, realizing even if a layman reads them, it is clearly written that land belongs to union there. So the bigger question is, what is the dispute? And what disturbed the ministry when this High Court order came? Very clearly, it was held that land which was of WOLFSBURN is a government land. So now the department immediately moved a review petition on this order and finally discussed B3 lands and old grants, and then various 8-9 judgments had already moved in by that time, which were in favor of the government. They mentioned those also, and they finally, this appeal also, this review got dismissed. So what is the main issue? Concurrent finding of the law of God. See, the entire dispute now is concentrating on what has the lower court said on these issues, and appellate also, and will these findings done will operate like res judicata. Now friends, I have been number of times saying, please dig in your old cases. I came across a case of Kasauli. I have come across some cases in Ambala where people in 1950s and 60s have fought small petty cases, and unfortunately or fortunately there have been issues decided of ownerships in those cases. So you are left with nothing. So, we really don't get to know. Now finally, this grant register, which speaks of Walsh settlements of 1842 and was even speaking of a line called WOLFSBURN is held on fee simple terms. No question of law, no vetting of this document was done down below. So there was nothing discussed. So second contention which he pleaded was it was an injunction suit, so you cannot make a finding on title. Again, section 118 of the Evidence Act, so many things, kept perpetrating this grant register, Exhibit 79C. You just kept harping on these documents which were there but not used. See, we have to understand why I talk of evidence. The smallest piece could be your evidence. Now with this judgment, entire LANDOUR has been labelled that it is a grant under GGO 179. And instead what Vinay Mehta ji says in her book, that LANDOUR, Banaras, Ambala and these some 4-5 cantonments did have private lands. So yes, this word fee simple can be dragged into, we can vet it out. But once again, to vet it out, we need these registers, we need these sale deeds, we need our old records. Department is not going to give us. Now let's presume, let's say somebody says, Ronnie ji, you make these videos, department is not going to give us, we are unable to find our records. Where is the law then written for it? Yes, it is written. The only savior which comes to you then is that yes, we are old grants. We were supposed to be converted by such and such orders into new grants. Now since we have not been converted, so we cannot be a grant under GGO 179 or either any GGO. If we are that, then we are a new grant. But if we are not a new grant and what is written in the GLR, we are an old grant, we cannot be a grant under GGO. So this has to be proved, not fee simple, my grant register or my sale deeds. Purushottam Das Tandon had dug into an 1845 sale deed, yet he lost in 2019. So this is how the whole case now goes. Now these sale deeds after 1937 I've been shouting. The department, the British, they all started taking admission deeds. Somewhere I have got documents where departments are even, drafting your sale deeds. They are imbibing a para which says that this land belongs to Union of India held under old grant terms of GGO 179. So let's say if somebody in Secunderabad sitting has a document like this, or if somebody sitting in Bombay Presidency has a document like this, where it speaks that this is a grant under GGO 179, so the whole pack of card falls. How? That has to be proved. So finally this case, these issues which were decided, finally they come up and they are in the Supreme Court under same Order 51 and Rule 22, Article 136. And this pleadings, case, SLP are now under mutinies. We are filing a counter affidavit. But what are we filing? Everything what we file after what we have in 1948. So this case now goes up and the court has to make its finding. Now it's very important what the court is giving a finding. It wets the entire pleading that whether in an injunction suit an issue of ownership can be made. It decides that. Further, it decides if the lower court finding and appellate court's finding on ownerships have been proved, whether through a document of sale or an admission deed, stands proven. Third, GGO 179's applicability was never an issue, but it is deemed to be proven. So now you can resume under Regulation 6. So everything in this case is now not working. So finally the court, I had number of meetings, the lady used to fly from Australia. We tried how to counter admission deed, how to bring in that when was the GLR made, because by this time we had even dug into our older registries of 1889 and 80. We travelled to Saharanpur, various places, Dehradun registry, and then we dug into all this. But this entire digging could have only been vetted if we had gone to the lower court, or the case would have been remanded back, which was not the case what Supreme Court was looking. Because it was looking on a very different angle which the Union of India pleaded, that this will go down to reopening the entire finding and it shall operate like a residue kata. Now to counter this residue kata, how do you do it? How do you counter residue kata or a finding on a particular issue? That can only be done under CPC if you are able to prove that the entire finding was on a fraud or a coercion or a misrepresentation. Some people shout, they don't want to listen, that Ronnie admission deeds were taken in coercive manner. What coercive manner? You made use of that document. Read the Document Act. Once you made use of a document, you cannot challenge that document then. and that admission deed has given you an entry in the GLR. Either you say you don't want the entry in the GLR. So somewhere these people, who don't understand, they keep harping on this side and that side. So never mind, when we lost this case, and finally you'll be surprised, I have read so many judgments of Supreme Court. In the concluding para, the Supreme Court even stated that the HOR, that is Mrs. Unniyal and ALOS, will hand over the possession of the bungalow by 31st January 2018. So just imagine, doesn't need to go in accordance with law. So PT Ankleshia, Purushottam Das Tandon, all judgments are finished. This is enough, this para for the Union of India. But we'll keep harping on PT Ankleshia or Pune judgments, 8 judgments, Purushottam Das Tandon, get the grant, admission cannot convert, various orders in CPC that admission does not transfer title. Agreed, yaar. Everything agreed. You have to understand the law. When this judgment finally came in, then I went in. And I slightly wanted, like, what Mr. Unniyal was actually achieving, because by this time, these ladies had already taken my entire research books from me. They paid me down. I don't say they paid from me my visits to Delhi or anywhere. Everything was paid. But there was a little backstabbing happening. These books finally reached not in Australia, but to the other bungalow owner in LANDOUR. Because he was facing some 4-5 cases. Demolition of bungalow, conversion of users of bungalow. So many things are happening against it. And this entire system was floating into that. And that's where I lost my sheen to this case. When you feel backstabbed, you don't want to do something. So finally I realized one thing, I must give my 100% to what Mr. Unniyal in 1985 pleaded. Mr. Unniyal pleaded for the right compensation. Rest he didn't plead. It was a suit for injunction. So bringing back that entire para 36 and 45, 42 to be more, what did they say? The appellant has rightly relied upon the decision of this court, which have exposited that determination of appropriate and reasonable compensation can be done even later by referring the matter to the arbitrator as per Harish Anand so-and-so case. That therefore cannot come in way of the appellant to proceed further on the basis of suit notice dated so-and-so, the validity whereof is unassailable. Para 42, we clarify that the respondents have any grievance regarding the quantum of compensation determined by the arbitrator in respect of the structure standing on the suit property, it will be open to them to pursue appropriate legal remedies as per law. Now I picked up these 2 paras and I gave my thorough confirmed advice that we are filing an application for clarification of these 2 paras. Can you imagine the AOR and the senior counsel refused to do this? Luckily, the daughters were on my side at this stage after losing. So finally, this application was moved as miscellaneous MA 16949 2017. And for the first time in the history of cantonments, under Regulation 6, the department had to answer back and say that yes, the bungalow owner is entitled to compensation, and a committee would be formed under a Government of India Ministry of Defence letter 1991 attached as Annexure R1, and a plot of 500 square yards. So the court finally pronounced this order that if all this is in place, the bungalow owner is entitled within 6 months the compensation to be decided, and if the policy permits for a 500 square yard plot may be given. You know, this was such a big achievement for somebody who had lost. That is why I keep saying this entire fight between a resumption notice and an old grant bungalow would not just begin from ownership or possession or correction of the land records. It will simultaneously even begin at the lower stage, how compensation has to flow in. And what did the British or the laws spoke of? So please be honest to yourself. This is all what I am trying to say. You know, I tried to help these people. They gave me their power of attorney later on. An entire GPAs, I represented their case in front of the station commander with two notions. They were served with a notice under section 244, which amounted to an amount of daily 10,000 fine from the date of your commercial activity. So I was skeptical and scared that maybe their entire compensation will get ruined. So I managed to convince the station cell, and I did it. But later it was history. The lady knows how much they talked to me, how much they paid me down. Guys, please, my request, please make sure you dig into your records. VR old grants never converted into new grants. Thank you.